Advocacy is an indispensable skill for an advocate. When a legal advisor puts forward a particular argument to a court with a view to persuading the court to come to a decision favorable to the client, it is advocacy. However, advocacy cannot be limited to oral arguments. On the contrary, it encompasses a whole range of skills which are invaluable to a lawyer. When I just started my profession as a lawyer, I heard a very eminent jurist say that a very good lawyer knows the law. However, a genius at law knows his skills. We have our distinguished guests here precisely to guide you to develop these skills to aid in your practice. Our guests need no introduction. However, I would take the privilege to briefly introduce you to their outstanding achievements and contributions to the legal spectrum. Honorable Justice Mukul Mudgal, former Chief Justice of Punjab and Haryana High Court and alumnus of Modern School, New Delhi, holds a BSc Honours in Chemistry from Hindu College, University of Delhi, and an LLB from Faculty of Law, University of Delhi. He enrolled as an advocate in 1973. He was an advocate on record in Supreme Court from 1978 to 98. He mainly conducted cases in civil law, constitutional law, labor law, and public interest litigation. Justice Mudgal was appointed a judge of Delhi High Court on March 2, 1998 and elevated as Chief Justice of Punjab and Haryana High Court in December 2009. He retired in January 2011. He has authored a book titled Law and Sports in India, published in 2010. Justice Mugdal successfully represented 8 banned cricketers as a counsel in 1989, appeared as amicus curiae in several cases in the Supreme Court for cases concerning prison reforms, environment, and as a counsel in the General Justice case Vishakha versus State of Rajasthan. He was a member of National Legal Services Authority and Governing Council of Indian Law Institute, currently member of Court of Arbitration for Sports, Geneva, and was the Honorary Secretary of International Law Association, India Chapter. He was the chairman of the drafting committee for the National Sports Development Bill 2011 and is the chairman of the doping probe committee constituted by the Ministry of Youth Affairs and Sports. He headed the one-man committee appointed by the Ministry of Corporate Affairs to probe the Walmart lobbying allegations and also headed the IPL probe committee appointed by the Supreme Court of India. I sincerely thank and welcome you, Your Lordship. Shri.
Hello everybody. It's very nice to be back in a webinar organized by my faculty. I remember the days, though the building was terrible, but the place was very great to be there. Didn't spend too much time in classes, but nevertheless made it past the exams. Okay, now we are coming to the question of advocacy skills. I'm so happy to have Mr. Vaidyanathan, one of the most outstanding lawyers, when he's practically my age, and we became acquainted in '78. And his senior, Mr. K.K. Venupal, the present Attorney General, was a great friend of my senior, Dr. Y.S. Title. And that's how we got introduced. And I must tell you that the first time Mr. Vaidyanathan had a plate of chaat in Bengali market, I had taken him there. So that's how deep our bond is. That was in 1978. Okay. Well, now let's come to the topic. The topic is really, in the sense, all of you naturally have to be prepared with your case. That is a given thing, and there are no shortcuts to that. All right. But now comes, you may be very well prepared with a case. When you go into a court, where you don't know the nature, philosophy, the views of a judge. Supposing you're appearing for a tenant and the landlord is represented by another counsel and the judge is an anti-tenant views because of something which may have happened to him or his experiences as a lawyer. And in that case, it is difficult to handle such a judge. Therefore, it is much needed skill of advocacy in courts to ensure that you read your judge, know his views, find out what makes him happy, find out what annoys him, and please remember 2 or 3 things. One, don't think judges are all angels. They may have had a fight with their wife. in the morning, and they may be very grumpy in the court. All that you have to read and make sure. Supposing the judge is losing his temper on almost everybody, best to get your matter adjourned on some pretext and come on the day when he is much cooler and listen to you with an open mind. So, therefore, read the judge, read his habits, find out if you have item number 40, don't go into the court by watching the board at 38. Go and sit in the court, observe the judge and his mannerisms. If he cracks a joke, even if it is so stupid, laugh at it, make eye contact, and observe how he has conducted the previous matter. So, one of the most important things in order to succeed is that you know the mood of the court, you know the mood of the judge, and therefore you have to read, you have to see what the background of the judge is, what what kind of cases he conducted before he became a judge. So all that kind of research there is. You are very lucky today to have one computer to put on two clicks and you get the case law. In our time, we had to go into the Quinquennial Digest, Centennial Digest, go through all the cases, pick up. It was heavy physical stuff, believe me, and including all dust-laden volumes. You are lucky that way. Therefore, please spend your time in researching the judge also, because eventually he has to decide. And judge, if the judge gets angry, be cool, don't retort, listen to him and say, Your Lordship is right, but may I then suggest one thing? I mean, there are ways of getting around it. Secondly, an art of interruption you only learn with experience. Young lawyers interrupting somebody may cause a lot of irritation to the judges. Don't do that. Thirdly, when you grow older in the profession, when you have learned how to interject, how to interrupt, sometimes a small word of interruption can disrupt the other side. And if a judge may have not picked up some misstatement, just point that out, sit down, but do it with experience. Don't do it immediately. That's my suggestion to you. And the other thing is, it comes to mentioning, for heaven's sake, don't ever mention a matter at 1 o'clock. Because what happens is judges in a hurry to get into the chamber for various reasons. And if you mention at that time, you're in for trouble. Best mention at 2 after lunch. That's one thing. The other thing, this is my experience in the Supreme Court, where I've largely practiced, in fact, solely practiced. And I want to give you an example. There was a judge, I won't name him. He appreciated lawyers who did not stick on in matters which were worthless. So I had once 2 cases listed before in his court. One item was a 50-50 item. I mean, it could have gone either way. One item was absolutely useless. There was no merit in it. I had advised the client not to waste money. He said, no, I'll take a chance. You never know. Now, my 50-50 matter was listed first. So what I did, I got that passed over by my junior. And when my useless matter came up, I told the judge, for the last half an hour, I've been thinking what to say to challenge the High Court judgment. I'm afraid I haven't found anything. The judge said, oh yeah, that's very fair, and it dismissed the SOP. And sometime later, the passed over matter came up. And I said, in this matter, I must insist, kindly look at this, the High Court reasoning. And, all right, notice and stay. So, all right. So this is, I mean, it's not misleading the court. No, it is only a tactic. Tactic in the sense it is ethical. You just have to read your judge and ensure in matters of this kind. So that is my advice to all the youngsters who may be listening to it. And in the sense that go observe the judge. Even if you're doing, my senior advice, Dr. Chitle advised me that even if you are not doing anything, don't go and waste your time in the canteen or gossip. Go and sit in courts, observe courts, learn from what happens in courts and all. So these are some of the things of advocacy which you will not learn in a book. This only comes with experience. And I'm sure, look, my advocacy stopped in 1998. Mr. Vaidyanathan's advocacy has continued even now. So his experience is much more on advocacy. I am giving you views from the other side. Also, 25 years of practice and about 13 to 14 years of leadership. So I'm giving you my views from both sides. Mr. Vaidyanathan will give you his views. And I would now invite Mr. Vaidyanathan to address all of you. Please come in, Mr. Vaidyanathan.
Thank you, Justice Mudgal. Good evening, everybody. It was very nice of Justice Mudgal to have introduced me. We have known each other for, as he said, more than 42
Sir,
years.
Vaidyanathan, sir, please let me come in between. I'm sorry I'm coming in between, but I just need 2 minutes before
Please.
you. Please, sir.
Please.
Sir, I would like to say this, that listening to sir was just amazing. Hearing the bench say such friendly things and teaching us like that is always amazing. And thank you so much, sir. But now, friends, you have heard from the bench. I would request the bar to speak to you now. I would like to introduce Shri Vaidyanathan, sir. Shri CS Vaidyanathan, Senior Advocate, Supreme Court, after completing law at the age of just 19 and a half years, could not enroll himself as a lawyer, as the required age for enrollment with the bar was 20 years or above. Thereafter, he joined a master's course in law and social work. After completing his higher studies, he opted for a job with DCM and joined the company as a senior management trainee. But you could all imagine that his heart and soul were in the legal profession at that time as well. He left his secure job and joined the chambers of Sri K.K. Venugopal in 1974. Later, he shifted to Delhi with Mr. Venugopal and was soon able to establish a name for himself in the profession through his hard work, his distinguished brilliance, and dedication. He became an advocate on record in 1979. In 1992, Sri Vaidyanathan was designated senior advocate. In the initial stage of his professional career, he was appointed as Solicitor General, Additional Solicitor General of India, and later on, he practiced as a private senior counsel. Today, Mr. Vaidyanathan is an eminent lawyer having an excellent standing at the bar. Some of the landmark cases he represented would include cases related to abolition of mandatory death penalty, right to education, reservation, nature of federal jurisdiction, banning of lottery, etc., which have been decisive judgments under constitutional law. In addition, he was also counsel representing the DT in the Ram Janbhoomi Babri Masjid land dispute case. His famous news article in the Hindu newspaper by the name of Down and the Bench exquisitely expounds the role of committee for designation of senior advocates for ensuring transparency in the process of elevation of the Supreme Court and the High Court. It is my immense pleasure to welcome you, sir. Sir, please take over the screen. Thank you, sir.
Thank you. Thank you, Justice Mudgal first, and thanks to the Lilly Law Faculty Alumni Association for giving me this opportunity to be with all of you. As was rightly pointed out by the person who introduced us, advocacy is not just arguing before court. The judge's perspective has now been placed by Justice Mudgal, and I think in a very sporty fashion. As a judge, normally one would be very reserved and withhold his views. But he has been a very eminent lawyer, successful lawyer, practiced in the Supreme Court, and has been a very popular judge. And irrespective of who appeared before him, if the matter deserved consideration, he had always granted relief. And that's the best that can be said of any good judge. Because if you apply your mind and if you grant relief, irrespective of the person who appeared before you. And he was able to bring out the best also in a young lawyer. And he always encouraged young lawyers. That's a great thing. Now to come back to the subject. Advocacy, is it an art or is it skill? or is it a combination of both? As a lawyer, one goes through the legal education. And when you come to the profession, when you first meet your client, I think that is really where the first test of advocacy takes place. Because with the client who has a grievance and is seeking justice and comes to you, you have to understand the facts, you have to gather evidence, you have to find out the pluses and minuses as to whether at all he'll be able to get any relief. Because his perspective may be different, but you have to put in your skill, your knowledge, your background, your experience, and then give him advice. And that, I think, is the first point of advocacy skill. Today, unfortunately, the lawyers are so keen to launch a litigation. I think one of the first steps that a lawyer should consider is this a case which is likely to succeed? Now, we need to scrutinize the facts, scrutinize the law, apply it and advise. Secondly, I think, is it possible to settle the matter before you launch? And today, fortunately, the pre-litigation mediation is a process which is gaining currency, and hopefully it will, in the days to come, get more acceptance. I think that is the second stage where one really has to show your advocacy skill. The third aspect, which is becoming even more important today with online courts and virtual courts and your social distancing, which we are experiencing today, is the need for excellent drafting skills. Your target audience is the judge. Fortunately, we don't have the jury in India. Your target audience is the judge. The judge has very limited time. There is so much of work that he has to handle. If you are able to effectively, very clearly, concisely draft your pleadings in an engaging manner, in an elegant manner, so that you are able to catch the attention. You know, I was an advocate on record from 1979 to 1992 when I became a senior advocate. A requirement of a synopsis was introduced. I would say a substantial part of a success as an advocate on record that I had was because of the fact that in 1 page or 1.5 pages, I was able to put over whatever was the injustice in the case which needed to be remedied by the Supreme Court. I think that if we are not able to make our point in 1.5 pages, because that is the time that you will be, the attention span of a judge is also limited. If you are able to attract his attention and therefore direct him to the relevant pages in the judgment or in the document, then your case is made. Similarly, in Supreme Court, admission matters particularly. The time that you get in most of the matters is just 2 minutes, 3 minutes. It's exceptionally you get longer. And if you have to, there you will know a mass of facts. You will have a lot of documents. You would have read all of them. But if you are not able to put over the case in a pithy manner in the first 2 minutes, you have lost the judge. That means you have lost the case, and that means you are not going to do justice to your client. That, I think, is the art which we must be able to. Therefore, today, there is even greater need for very concise, precise draftsmanship in regard to pleadings, in regard to written submission. I have seen plaint which is 1.5 or 2 pages long. I have seen writ petitions which will be hardly 2 pages, 3 pages. 1 point, 2 points, most of these have 1 or 2 points. You might have 10 different points. First appeal or second appeal normally should be in 2 pages, 1.5 pages. There is no point in having long submissions. because the judge doesn't have the time to read, and you're not going to argue all of them. If you are not able to put over your best case, first 1 or 2 points, then you're not going to succeed. Ultimately, we have to see who is my target audience. As a lawyer, your target audience is the judge. You are not arguing only for satisfying the client who may be sitting at the back, but you have to get relief for the client, and therefore you have to satisfy the judge. And that is where I think it is important. The 2 or 3 other things which I want to mention. One is, the clients come up with several aspects which according to them are the best points. The client necessarily does not have your knowledge, your skill, background. Therefore, you should, as Justice Mudgal pointed out, you should be able to assess the judge. Now, the list comes the previous day. There are judges and judges, each one, you study the judge. You know what is his strength, what is his approach. Is it the equity-oriented judge or a technical point-oriented judge? Then you have to decide which bills you will be able to put over. Because ultimately, there is a lot of psychology also involved in this. You have to assess the judge because he is going to give you the relief. You will have to put over. I think that is important. Now, when arguing, Justice Mudgal mentioned about interruption. 2 or 3 things I want to mention. One is, if a judge asks a question, always answer. Don't avoid answering the question. Then that will put him off. You are not going to get a relief. You can't just get away by not answering the question asked by the judge. You have to be very fair to the court. Never ever misrepresent the fact. You are not arguing only one case. You are in a profession. You are going to continue in the profession. Your reputation is built on that. If the judges know that you will never misrepresent, you will set out the correct facts, and you have studied the case, and you will place all. If you know that there is a judgment directly against you, and if you don't place that, you must be able to distinguish it. But if you try to suppress it, we can't assume, and it will be wrong for anyone to believe that the judge doesn't know the law or the other side is not going to point out. See, in an adversarial system, you'll be caught out. It is right to be fair to the institution, to yourself, to your conscience, and to your client. You have to point out whatever is in your favor, and the other side, of course, will point out whatever is not. But you must be able to anticipate what is going to be pointed out and prepare the judge in advance. Look, these could be argued, but these are my answers for it. In some instances, even if the case law there is a case law against you, and if you can distinguish it, please do that. That, I think, is an advocacy skill. Today, the other advocacy skill which is most important to be a successful lawyer is in obtaining interim order. I think you have to be quick on your feet. You have to anticipate what question, what is the kind of interim order that you will possibly be able to get from the judge. And based on that, you should be able to see, take, for example, there was a case where we were for the appellant, and it was a party dispute. And the judges, they were inclined to admit the matter, but not grant. Then the property, the possession will go. So the best thing at that stage was to offer, don't continue. I will continue in the possession, but as a court receiver, I'll be accountable to you. That was an acceptable suggestion, not a blanket stay, but as a court receiver. So the court thought, yes, it's a good thing. Like today, any number of cases which come up, intellectual property or matters in regard to tax, there are money payments involved in these matters. Sometimes demands have been made and you may be required to deposit. Now, intellectual property matter, you are appearing for, let us assume, a person who has the patent or any copyright. Now you say that the other person has breached and he has not taken a license. Now you will have to point out the equity and say that you have to make the defendant at least deposit the money so that the person who is already taken out a license from you, doesn't suffer. Now, I think in regard to the interim order, it is very, very important that you go prepared in advance as to what the court is likely to ask and what you have to. I then come to one last issue. You are a lawyer. Advocate's skill is needed. But to be a successful lawyer, courts, law books are not the only thing. You have to have a variety of interests. If you are a good sportsman, continue to engage in that. If you are interested in music or painting, continue to be involved. You must have other interests. It is important for a lawyer to be a successful lawyer, not just to be in law and argue. I think this has to be kept in mind. All of you should have some other interest. If you like travel, if you are a good photographer, please continue this skill, and you will develop new friends. You will the new vision. When you go out into the world, you have this interest, literature, everything. The vision will be completely different. That's the last thing that I wanted to say. Thank you all very much for this opportunity. May I now request that whatever are the questions, both Justice Mudgal and I will be very happy to respond to them.
Can I just add to what Mr. Vaidyanathan said? He said many more things which I should have said. And I'd just like to reiterate two things he said. One, a lawyer must have other interests. I mean, I was in two collegiums, and frankly, I thought that when appointing a judge, you must see what your interests are in life are, And a person who has interest in fine arts, music, sport, anything, poetry, pottery, he's definitely a better human being. And unless you are a good human being, you can never be a good lawyer or a good judge. Second thing is about misleading. Please remember, if you mislead a judge, don't think it's only he will remain informed about it. Sure as hell, they will discuss it at lunchtime or tea time when the judges meet and congregate, and your name will get bandied about. So good reputation may not travel fast, bad one does. That's all. Thank you.
Thank you so much, Justice Mudgal and Vaidyanathan, sir. It was really intriguing and amazing to hear the insights of two established professionals in this profession. Sir, there are many questions popping up by various members of the audience. The first and the foremost question that has been popping up continuously is that, sir, this is coming from the perspective of a first-generation advocate. That how should a first-generation advocate start building his practice so that it becomes more and more sustainable in the near future?
Who's to answer that? Okay, I'll start with it. Yes, both me and Mr. Vaidyanathan are first-generation lawyers.
Yes.
Am I right, Vaidhi?
Yes,
absolutely.
My parents were classical musicians. Mr. Vaidyanathan's parents, he'll tell you. And it needs a lot of hard work. The person who has a family in it does get a head start, but it doesn't last long. It's like that you're an opening batsman. Okay, first 5, 6 overs you may not get out, but eventually you have to work your way up. And just because your father is something, eventually you may not succeed. You may have seen several persons who were launched by their family, but eventually came a cropper because they were not made of the stuff which makes success. So that's one thing I'd like to say. The first generation lawyers will have difficulty. Yes, first for 5-10 years are tough, but you have to bear it. Please remember, in the beginning, the income doesn't come. Later, you have to work very hard without much return, but later you may not work much, but the returns would be there. So, Mr. Vaidyanathan may like to add something to this.
See, Yes, Justice Mudgal and I both are first generation lawyers, but we were fortunate in a sense. Justice Mudgal could start with Dr. Chitle and I could start with Mr. Vanagopal.
Yeah.
Now, that gives a tremendous amount of opportunity because the kind of cases that both handle is, legendary. Was an experience. Not everybody will get there. But then, see, we have to make sure, even when we had that opportunity, there were so many in our office. Now, at the time when I joined Mr. Banagopal, there were 13 juniors. So, in 74 June, when I joined, I was so lucky that by August, Mr. Vanagopal said that you go and argue your first case. And Mr. Vanagopal came and sat next to me in the court when I argued. So that is only because I was able to demonstrate to him and convince him that, look, I would be able to do it. And therefore, you have to put in a lot of it. And those days, as Justice Mukul said, we didn't have all the convenience of looking up the case law through the computers like we have today. So we used to work till 11:30 at night and maybe sometimes even later and get up early in the morning and be ready. And, if a client comes, sit with him. So 6 o'clock he comes. Those days, you you first sit with him, understand, go through the document. By 7:38, you start dictating the petition. Next morning, the stenographer will bring it. You have it corrected, and the stencil will have to be rolled. You don't have the facility like today. You have the printer, so the stencil will have to be corrected. Stencil will have to be rolled. Then it will have to be filed in court at 10:30, and if urgent orders are needed, you go and mention to the judge at 10:30. Look, this is urgent order is needed. A lunch motion is needed. Get the order. If the matter comes up at 2:30, get the order, and then in the evening the client will leave. If you are able to do that, if that is the kind of hard work that you will have to do, you can't say that, no, today I have to go for a movie with so and so. Sorry, that can't work. When you start in a profession, your profession will have to be the focus. If you do that, you are bound to be successful. I assure you, there is no single instance of any person who has put in that kind of hard work who has failed. And that is what is needed.
Sir, the other question, sir, thank you for the great insight that you have given us. That now that we have begun to realize that how difficult it was in those days and how easy we have in these times. Sir, the second question that has been popping up is that there are many clients that have very unrealistic and very high expectations out of advocates. So, sir, how to meet those expectations? How to tell the client that what the reality is, what the due process is, and in that eventuality, how to convert that client into an actual client?
You
So,
better talk, Mr. Vaidyanathan. First, I'll come in later.
Yeah, I'll give you two instances with an extremely difficult client. The former chief minister, who is no more, Jayalalitha. Now, I was appearing for the state of Tamil Nadu in the Kaveri dispute. The dispute was with the state of Karnataka, but there is more politics in river disputes than even real, water sharing, etc. Now, if a particular stand is taken by the chief minister, immediately the DMK will say, look, the chief minister has given up this point. So there was a 1924 agreement. And the relief had been sought only on the basis that the 1924 agreement with the old Mysore state should be the basis for getting the relief. And she said, no, you don't understand. Mr. Vaidyanathan, you don't understand politics. This is how it has to be done. I said, madam, no, you are right. You have to do that. But if you don't have an alternative relief in regard to how much water you require, and then make an assessment and then put it in your pleadings or evidence, the judges may not accept it. If you rely only on the agreement, ultimately, if the agreement is held to have lapsed after 50 years in 1974, which is what happened, the tribunal said so, Supreme Court upheld. But because I was able to persuade a difficult client to accept that this is the reality, you may not succeed in that, therefore you have to have an alternative case. She took time. But the lady was so good, she studied all the papers and then called for another meeting and then agreed with me and then met. Another instance of the client. See, the Rajiv Gandhi assassination case. There was a conspiracy angle in regard to whether DMK had any relationship with LTTE and therefore that had caused this assassination. Politically, she was making speeches and saying that, look, the DMK leaders had tie-up with LTTE and they were involved. Jain Commission issued notice to her for coming and giving evidence. So she said, I have to say all this. I said, Madam, what kind of evidence do you have? Other than the kind of press reports that you have heard, do you personally know of any involvement of any of these persons? If you are in the witness box, you'll be grilled and you'll be exposed unless you have real substantial material. You show me that and then we will consider it. So for her, look, I have been all the time telling the people in the public forum, in the political meeting, that they are responsible. I said, you say that newspapers have hinted this, all these, whatever it is. There are persons who have spoken about it. I have no personal knowledge. But this is a matter which requires investigation by expert teams. That's something which you can pass off. You will be able to tell the sustain cross-examination on that basis because you don't have any personal information. So it took some effort, but she got convinced and she changed the affidavit which was prepared originally by her. It was changed, and then in half an hour her cross-examination was over because she was only relying on other reports and therefore those had to be investigated. Otherwise, she would have been subjected to grilling for 2-3 days. I mean, you have difficult clients, you have to deal with them. You have to persuade them. That's what I would say. This is Mudgal.
Yeah. Look, I'll give you an example of a client from Punjab who came to me to file a special leave petition. So he said, "Sir, stay mil jayega na?" So I said, I can't promise you stay. I'll do my best. Then he said कि नहीं, वो जैसे साथ वाले चेंबर में जो हैं वकील साहब, उन्होंने कहा नहीं स्टे और वो पक्का मिल जाएगा. मैंने कहा फिर आप उनके पास चले जाइए, मैं तो आपको एडवाइस करता है. So he went to that lawyer. I don't know what happened in any case. And a month later, that man was a litigious person. He had many litigations on land. He turned up in my chamber. So said, I said, "Acha, batai kya hai?" So he said, "I have this case and all that." But I said, "Okay, so we will do something. I think you have something to say here. But please remember, in Supreme Court, it's always risky. 90% SLPs do get dismissed. And I must tell you my personal experience. My first 10 SLPs were dismissed. The 11th one where I succeeded, I was a caveator and I was not called upon. So that's how my career started, okay? So anyway, so he said, "नहीं sir, आपने उस वक्त ठीक बोला था, वो खड़े ही हुए, the court dismissed the petition straight away. There was nothing in it. And I was misled by him. And I have come to you because you told me the truth." Okay. So you may lose some clients, but you establish a reputation of being a person who does not mislead, who does not give false hope. You develop that reputation. People will start coming to you slowly, but steadily, and thereafter more and more of them. Because of word of mouth, lawyers practice only by word of mouth. Okay.
Thank you for the insightful answers, sir. It has really been an eye-opener for all of us because realizing.
Would you allow me? Can I ask a question from sir?
Please, sir.
Yeah, please.
So there is a very important question which has been bothering me also from some time, and there have been many queries regarding it when I was looking at the queries. Sir, is it really necessary? Because many of advocates, new advocates, don't get an opportunity to work under senior advocates in their initial years. Is it really necessary to work under a senior advocate? And if not possible for him, what are the remedies? What are the other options he should do?
Mr. Vaidyanathan, you'll be a better person to answer.
See, I think for a fresher from a college, from a national university or otherwise, I don't think starting with a senior advocate, particularly in Supreme Court, is beneficial. The reason is this: the senior counsel, and we, at least most of us follow this. We don't run an office. We don't meet clients. Others come and brief us. When others come and brief us, they expect us to argue. It is they come to brief you only for you to argue, not for your junior to argue. So the junior's role is very limited. The junior will not get a chance to draft the pleadings. The junior will not get a chance to argue. But the only help that the junior will render is in preparing a list of dates or briefing you in regard to what the case is about, or in giving you the case law, doing some research in regard to the case law and all. Now, that is a very, very limited role. That means you are not going to get that opportunity. Whereas, if you are with an advocate on record in the Supreme Court, you will get a much better opportunity. And that too, if you are with an advocate on record for the state who has 15 cases in a day, you will get a chance to at least say, take a passover, gain confidence, and then get a chance to argue. And you will get a lot of chances to draft the pleading. Therefore, I think that is where it starts. In high courts, it can be slightly different because in some of the high courts, some senior advocates, juniors, get a chance to prepare the pleadings or etc. But I don't think it is so in the Supreme Court. Justice Mugdal will be able to supplement.
No, I absolutely agree that while I benefited from the extraordinary influence the Supreme Court had on me and my senior training, I must now give you an actual instance. My senior told me there is an application. It was listed before Justice Alagati Swami in court number 5. You read the brief thoroughly and then move this application. Well, I went to the court. I was fully ready with the case, 2 pages of notes here and there and all. And when I stood up, the judge said, "Okay, allowed." It was an application for withdrawal of the appeal, And my senior, I went to Dr. Chitta. I said, "Sir, you made me read all this, and it took half a second. And before I could open my mouth, only warm air came out of it. And the court said, allowed, next. So I said, why did you? He said, look, whenever you go to court, even for asking for a passover or an adjournment, you must know the case. The idea was to acquaint you with it. Next time you go to a court, you'll be well prepared. So please remember this. Now, it's a lesson I got practically. I mean, preparing a brief thoroughly for an appeal withdrawal. Can you imagine how my senior misled me to become better?
Training.
So seriously, listening these reassuring things from your mouth is wonderful. Because many students are really confused what to opt after once their law is over. Sir, one very small query, one more query, sir. Once a person has been working under a senior advocate or some other advocate, what is the time he should feel that he should start an independent practice after that?
See, I have always believed that no junior should continue with me for longer than 3-4 years. You should be able to develop your own independent practice in the meantime and start on your own. And unless you go out and take that risk, you are not going to succeed. For 3 years, please.
I would say 3 years, at least 3 years, and not more than 4 or 5. Don't stick on too long. Otherwise, it's tail court. In the sense that you will always be hanging around. You will not be. You have to take the plunge, as Mr. Vaidyanathan said, and take the risk. of going out into the open. And
that is very insightful.
it's like that. And yes, our profession is a risky profession. Not everybody succeeds, but luck plays a little bit part, but hard work is the most important. I would say 80 to 85% is hard
Right.
work. Luck will certainly play a part, which always does in any facet in life.
So just one question that has been popping up again and again. Another question that is, sir, a lot of new first generation advocates, they find it very lucrative to cross some ethical boundaries at times. What should a first generation advocate do so that he or she does not cross those boundaries and become so to build that sustainable practice? How do they stop themselves from crossing any ethical boundaries? That is a very important question that has been popping up, sir.
I think Mr. Vaidyanathan would be better suited because of his experience and larger experience in the bar.
See, it's a very difficult. It's not just for a lawyer, for any professional, any human being. The moment you start making a mistake, you're gonna stray. I think it's going to be very, very difficult to retrieve that situation. Once you have made a mistake, then once you cross that boundary, then it becomes a kind of routine thing. So it is a huge sacrifice to be able to withstand that pressure and not cross that boundary. But it is important that you don't. If you fail in that, you have failed as a human being, not just as a professional, but you have failed as a human being. Therefore, it is difficult. And today, at the time when we were doing law, the legal education was not so costly. Today it is extremely expensive. Several people borrow, and they have to repay. They have the EMI payments to perhaps discharge. I quite understand that situation, but if you slip up, then there is no recovery. One has to be extremely guarded. And I tell you another thing. You are in the profession not merely for earning money. You have to see, Justice Mudgal and I, we have been together in a number of public interest petition pro bono matters, and the greatest satisfaction that you actually get is by doing those matters and the amount of effort that you have to put in. Therefore, money is here, but initial years you have to do hard work, as Justice Mudgal said. First 5 to 8 years, don't even expect to be able to satisfy your full needs. Forget about your extra comforts and the greed. If you are able to satisfy your needs during the first 5 years, you should be happy.
Sir, due to paucity of time, I'll have to ask one final question only because we have to conclude as soon as possible. So just one last question is that sometimes we, as law students, as people who are uh, planning to join the legal profession as an advocate, sometimes there is some resistance because of the image of advocates that has become these days. That as a whole, it is becoming more and more tainted by the day. So, how, as members of the same fraternity, how can we revamp and rebuild that image, sir?
It's a very difficult question, let me tell you, because look, the lure of money is very strong, and I mean, people want to go to corporate offices, but then get burned out very soon, or get used to the salary, and then are not able to break free, because if you have responsibilities. So, therefore, I think, in the sense, image building is a very tough thing. You have to build your own image. You can't take the responsibility of the entire profession. Yes, there are bad eggs in every profession. There are bad eggs in every profession. But certainly what you do is you establish yourself as a clean person. Try to join if you're joining somebody senior, try to join a person whose reputation is good. He may not be the most successful lawyer, but if he's got a good reputation, go and join him. It will be much better. Mr. Vaidyanathan would like to say something.
I just want to add one thing. Look at this. The public has the greatest confidence in the judiciary, even today. Please be proud of the fact that we are part of an institution in which the people have the greatest confidence, notwithstanding some weaknesses may be there, but even today, the people's greatest confidence is in the institution of judiciary. And you, as a lawyer, you are an integral and important part of that institution. Be proud of it. I think, therefore, that should add value to your being a lawyer.
As sir, it is very natural that we would have wanted
just intrude for a second. Sir, on a lighter note, I just wanted to know one thing. Vaidyanathan sir, you said that luckily we do not have jury these days. Sir, is it really lucky to or unlucky for us to not have jury these days?
I think it is we are lucky because this debate goes on about this public morality and all this kind of thing. The jury will go on public morality, majoritarian sentiments. Now, that's a very dangerous thing. As a judge, you expect the rule of law, justice, just fair and reasonable dispensation of justice, subjective satisfaction on objective material. That's what you want. But in a jury, it will be subjective satisfaction on subjective considerations. Please don't do that. That's very, very dangerous thing.
As much as we would have wanted this discussion and this program and webinar to continue, we are short of time, sir. But on behalf of the entire Delhi University Faculty of Law Alumni Association and on behalf of all the organizers and in charges, I would like to thank both of you, sirs, for taking out your precious time in this day and age. And we cannot thank you all enough for taking out your time and giving us an insight into this profession from both angles. And it was very, very important for us, sir. And thank you very, very much for your time, sir.
Thank you all for hearing us. And as far as the valuable time is concerned, these days, at least I am doing nothing. Okay.
Don't say that you are involved in so many organizations.
Good
that you put me. Good that the Delhi Law Faculty put me in a joint panel with Justice Mudgal. We have been good friends for a long time. Thank you very much.
Really.
Okay, bye everybody.
Thank you so much.
Thank you so much. Thank you so much for your time, sir.
Okay.
Definitely, sir. Thank you so much.
Thank you once more, sir.
Thank you, sir.
Okay.